Good morning, everyone. So today we are going to start up with the topic, the Indian Contract Act 1872. My name is Gurveen Kaur. I'm Assistant Professor in Department of Management Studies in Amritsar College of Engineering and Technology. So this is under the Merchant Law, and the act is Indian Contract Act 1872. So before starting this, let's understand what is a business law. So business law is a rule which helps us to regulate and manage our business transactions and activity system. It has direct relation with the trade, industry, and commerce. Example, the Insurance Act, Contract Act, Tax Act, Sales of Goods Act, Agency Act, etc. So business law is an act, a business act, which is dealing with all these business activities. The business activities may include the Contract Act, it may include the Consumer Act, it may include the GST Act, the Goods, Sales and Goods Act. So all these acts which are related to any of the business transactions or any of the business activities which are working in their day-to-day routine, that is going to deal and that is going to come under the head of the business laws. So under this, one of the act is the Indian Contract Act 1872. It was enacted by Parliament of India on 25th April 1872. The date of enactment and the date of commencement was 1st September. The date of commencement was 1st September 1872. It has total sections of 238 and it is extended to all the states of India except the state of Jammu and Kashmir. So to all over India it is applicable, but it is not at all applicable in the state of Jammu and Kashmir. So it is the under the Parliament Act, the date of enactment was 25th April and the date of commencement was 1st September 1872, and it consists of total section consists of 238. Now under this, what is a contract? An agreement which is legally enforceable alone is a contract. An agreement which is legally enforceable. An agreement is when we do an agreement, a verbal agreement is between the two parties. But when it is in a legal binding, when it is in a written form or in a legal binding, it will be known as a contract. An agreement which are not legally enforceable are not contract but remain as a void agreement, which are not enforceable at all or as a voidable agreement which are enforceable by only one of the parties to the agreement. So this is being done by one of the parties, and one of the party is not understanding it, when one of the party is not working accordingly, then it remain as a void contract or a voidable when one of the party is not accepting that agreement. So contract basically means an agreement with the legal binding that becomes a contract. All contracts are agreement, but all the agreements are not the contract. So once an agreement is made, then it will happen a contract. So every contract will be an agreement, but it is not at all necessary that all the agreements will be a contract. All contracts are agreement because they must be mutually understanding between the two parties for a contract to be performed. All parties should agree and adhere to the terms and the conditions of an offer. So that is into the offer part. So an agreement, when it is enforceable by the law, then it becomes a contract. So under the contract section 2H, an agreement enforceable by law is a contract. So contract is under the contract section 2H of the contract law. So what is contract? According to the section 2H, a contract is defined as an agreement enforceable by the law. What is an agreement? According to section 2E. Now we know that every act which is enforceable by the law, it have different various sections. Like in the Contract Act, we have 238 sections. So according to the section 2 subsection H, according to the section 2 subsection E, every promise or set of the promises forming the consideration for each other, that is known as the agreement. Next, promise. According to the section 2B, when a person made a proposal to another to whom the proposal is made, if the proposal is assent thereto. So that is a promise. When one makes a proposal to the another and another accept that proposal, then it becomes a promise. Suppose I and my friend, I give a proposal to my friend that let's go for a dinner today, and my friend accept my offer. Then this acceptance of the offer by my friend and offering an offer to my friend, both the things are mutually happening, and that becomes a promise. So I offered him for a dinner, he accepted that, we went for the dinner, that becomes a promise. So that is a promise. Next, according to section 2A, what is an offer? When a person made a proposal, when he signifies to the another his willingness to do or to abstain from doing something. So that becomes an offer. So what is an agreement? Offer plus acceptance, that becomes an agreement. So I offered to my friend that let's go for the dinner. So that was just an offer. Again, he replied that okay, yes, we will go for a dinner. So that was the acceptance which was given by him, and ultimately this offer plus acceptance becomes the agreement. Now, another condition would have been, I would have offered to my friend, let's go for the dinner, and he would have said no to it, then it is not an agreement. So offer was abstained. So see towards this diagram, a contract is basically agreement plus enforceability. Now agreement is further defined as promise and consideration. Promise is further defined as an offer and as an acceptance. So there are three things which are going together. So contract, when an agreement is enforceable by law, that becomes a contract. And agreement when it is having a promise and the consideration. Further, a promise is when an offer is given and acceptance is given towards the same thing, that becomes a promise. Now, agreement, promise forming for the consideration means agreement is equal to the promise plus consideration. So, social agreement or the legal agreement in terms of legal agreements. Let's see further. Now, next is what are the essential elements of a valid contract? Under the section 10, the first is the offer and the acceptance. Second is intention to create a legal relationship. So offer and the acceptance, first we will consider the first one. Offer and the acceptance is when I offer something to someone and the person give the acceptance towards it, that okay, I accept your offer. So that is into the offer and acceptance. Next is the intention to create a legal relationship. When an offer is given and it is accepted by the another party, then we will go for the legal relationship. Legal relationship means we will be going for in a written form. So that written form would be known as the intention to create a legal relationship. Then coism ad idem. So that is when it has gone for a legal agreement. It has been done in a writing. That is known as the coism ad idem. Next is the consideration, capacity to contract, free consent, legality of the object, possibility of performance, writing and registration. So consideration is when a person is going to give the consideration for it. Okay, I give an offer and the same person is going to give something in return. So that is into the consideration. Something in return is given. Capacity to contract, who all can go for a contract. So which parties, who all are able to go for the contract. Free consent, the consent would be given in the normal form. So it will be free. Legality of object, we are going to go in a legal binding only. We are going to follow all the legal obligations over there. Possibility of performance. So possibility of performance means that is an contract able to perform. So is there any possibility to happen that contract, it can happen or not. And writing and registration, then finally it is done in a writing. It comes in a form of a contract and in a legal binding. Now, next are the types of contract. So first type of the contract is a valid contract. That is an absolute contract, contingency contract, section 31 to 36, express contract, implied or coercive contract under the section 68 to 72. So first is the valid contract. if all the conditions are fulfilled, it is called a valid contract. When everything is going in a proper way, in a aligned way, and everything is fulfilled, every condition is fulfilled, that contract is known as a valid contract. Next is the contingent contract. In a contract, to do or not to do something, if an event is collateral, does or does not happen. When the things are happening, it may happen or it may not happen, that would be known as the contingent contract. So the things may happen or it may not happen. So when there is some doubt over there, fine. So that is known as the contingent happen. A contingent contract means we are having some doubt. We are having some doubt in few conditions that it may happen or it may not happen. Express contract, when the contract are either in writing or in oral. So everything is writing or everything is told. So it will be an express contract. I have informed each and every condition. I have given it in writing also. So that is expressed. I've explained it. Next is the implied contract, when the contracts are neither in writing nor in oral. I told that I'm going to go for a contract with ABCD person related to this. Now I have told that it will be related to a property, but I have not at all informed what will be the conditions, what will be the legal bindings under that, what conditions are going to be fulfilled, what conditions are not going to be happen over there. So I have not told, we are not having a single information related to that contract. So it will be known as the implied contract. So we have done the four contracts: valid, contingent, express, and implied contract. Next is the invalid contract. So it consists of the void contract, is void, voidable, intio, then become void, then voidable contract, illegal contract, and unenforceable contract. So invalid contract. If a contract, if any one condition is not fulfilled, when any of the condition is not fulfilled, any one of the condition out of, suppose there are 10 conditions and 9 are fulfilled, one is not fulfilled, then it will be an invalid contract. Is void or voidable intio, an agreement which is not valid from the beginning only. So since beginning only, we know that this cannot happen, but then also we are trying to make it as a contract. So that is known as is void contract or voidable intio. Then become void, an agreement which is valid in the beginning, but due to some supervening impossibilities, the contract become void. So in the beginning, we were knowing that, okay, this can happen as a contract, the things can happen, but due to one or the another condition, the one or the another possibility or one of the another impossibility, the conditions were not fulfilled, and afterward on the later stage, it become as a void contract. So that is known as the becomes void contract. So is void is when the contract since beginning it is not possible, but become void means it was possible in the beginning, but due to some condition on the later stage, it was not possible to become as a contract. So it becomes a become void contract. Next is illegal contract, an agreement forbidden by law. So in front of the law, it is not possible to happen. So that is the forbidden by law. So it cannot happen. The law cannot give the permission to become as a contract over there. So that is a forbidden by law. Unenforceable contract, it is valid, but due to some technical defect, the contract become void. In case defects are removed, then the contract is enforceable. Lack of registration, lack of signatures, etc. So unenforceable contract is a valid, but due to some technical defects, the contract become void. Contract is valid, the contract can happen, but due to some errors like signatures were not proper, photocopy of the page was not there, printing was not clear. So due to some technical error or lack of registration was not done, or the registration number is not referred, stamp is missing. So due to some technical reasons, the things were not happening. So that becomes unenforceable contract. Unenforceable contract. Everything was contract, but due to some technical reasons, the contract is unenforceable contract. So further, other types of the contract are executed contract, executory contract, unilateral contract, and bilateral contract. Okay. So first is executed contract. In a contract where both the parties have performed their obligation, there is remaining nothing to perform. So that is executed. Both the parties have done their work. So it will happen and it is going to happen. So that is known as the executed contract. The things have happened. Executory contract, in a contract where both the parties are yet to perform their obligations. So both the parties are yet to perform their part. So that is into the executory contract. Unilateral contract, in a contract, one party has performed his obligation and other person is yet to perform his obligation. So that is known as unilateral. One has done his part, another is pending. So another party part is pending. So that is known as the unilateral contract. Bilateral contract is when both the parties have to perform their obligations. So in a contract where both the parties have performed their obligation, bilateral, executory are the same and interchangeable. So bilateral is both the parties are yet to perform their obligations. So both the parties are into the pending part. So it can be changed interchangeably. So executory, second one, and bilateral. So executory is when both the parties have done their obligations, have completed their performances. Bilateral is when yet it is to be performed by both the parties. So next we are going to consider the offer. So what is an offer? According to section 2A of the Contract Act, when a person made a proposal, when he signifies to another his willingness to do or to abstain from doing something. So that is into the offer part. So offer is something very simple. When I'm going to offer something to someone, suppose I offer a chocolate to my friend. So it depends upon my friend that he is going to accept that chocolate or he or she is going to say no to that chocolate. So if he or she accept that chocolate and consume that chocolate, that is an offer. Okay. I offered something and another person has accepted that thing. Another condition would have been, so if he has accepted, he or she has accepted, then it is an offer. Another is when I have offered and they say no. She or he say no, then it is not an offer. So next are the types of the offer: express, implied, specific offer, general offer, cross offer, counter offer, and standing offer. So let's do one by one what these offers are. So first is the express offer. When the offer is given to the another person either in writing or in oral. So I have expressed my offer. I have given chocolate to my friend. So that was oral offer which I have given to her. Then is implied offer. When an offer is given to the another person neither in writing nor in oral. Implied offer, that is in my mind that I will give this chocolate to him. So I have kept that chocolate over there, but I have not informed her that this chocolate is for her. So I have neither given a written note nor I have told verbally. So that is an implied offer. Specific offer, when the offer is given to a specific person, it's only for a specific person. So this offer is only for my teacher. I have bought the books, some special books for my teacher, for my professor. So that is a specific offer which is only for my professor. That is not for anyone else. General offer, when an offer is given to the entire world at a large. So that is over a large. So that offer is given to everyone. Like marathon is there. So marathon is at a common point. So marathon is an open invitation to everyone that come and join the marathon. So whosoever get registered, they come for the marathon over there. So that is a general offer. It's happening in general. Next, cross offer. When both the persons are making identical offers to each other in ignorance to another offer. So identical offers are being made. So that is the cross offer. So that is into the cross offer, ignorance of the other offer. So we never know that the another person would have given the same offer over there. So when the same offer is given by two person to the person, then it becomes a cross offer. Counter offer, when both the persons are making the offer to each other which are not identical in ignorance to the other offer. So they both are not identical, but they are happening over there. So that becomes a counter offer. So that is into the counterpart only. Cross offer means when I am also giving a chocolate and the another person is also giving a chocolate to me. Counter offer, I am giving chocolate, he is giving something else to me. So that is into the counter offer. So counter has happened over there. So that is in ignorance to the offer that a person is knowing or not. Then is the standing offer, an offer which remain continuously enforceable for a certain period of time. So that is enforceable for certain period of time. So that is a standing offer. Suppose I keep maid at my place. So I have made a contract with her that yes, you are going to work in my place for 1 year and you will be paid such and such salary for the same. So that is a standing offer which will be enforceable and continuously for certain period. So for 1 year, that is an offer which I have given to her. That was a verbal offer which is given to her, not in writing or not in a contract form. So that is a standing offer that remains standing. So standing for 1 year that she will be working at my place at 3,000 per month. So that is a standing offer. So 1 year it will remain over there. So legal rules for the offer are, offer must be given with an intention to create a legal relationship. So that is legally binded. Offer must be definite. It must be defined over there. There is a clear cut difference between the offer, invitation to offer or invitation to sale. Now, there are three things over here. Invitation, first is the offer. When I have given some offer to someone, he or she accept that, that is an offer. Invitation to offer. I want to give you a chocolate. So I have given him the invitation. If that person say, okay, yes, you can give me, then I will hand over that chocolate to that person. So that was the invitation. Do you want to eat chocolate? Shall I give you a chocolate? And here's the chocolate. So first I have given the invitation and then I have offered the thing to him or her. Next is invitation to sale. Do you want to sell your bike? Okay, at what cost? Fine, I want to purchase that bike. So that is an invitation I have given to. Do you want to sell your bike? Or here is my bike, I want to sell it. Do you want to purchase it? So that is an invitation which is given to one person. So that is an invitation to sell something. So legal rules would be giving an invitation and offering that thing over there. So next we are going to do is acceptance. According to section 2B of the Contract Act, when a person made a proposal to the another to whom proposal is made, if the proposal is assented thereto, it is called an acceptance. So when a proposal is made to someone and the another person on the same time is going to give the acceptance for the same, it becomes the acceptance. So acceptance must be given as per the mode of the preside by the offerer. So who is the offerer? Who is going to give the offer? And offeree, who is going to accept that thing. Acceptance must be given before the lapse of time or within the reasonable time. So that is into the acceptance part. Next, acceptance must be unconditional. Acceptance must be given by any person in case of the general offer. So in case of general offer, it can be given by anyone, and acceptance is not at all having any of the legal conditions. So it is known as the unconditional one. Acceptance must be given by any specific person in case of the specific offer. So it can be given by anyone at any time. Acceptance must be communicated. It must be clearly defined. Everything must have been told. Everything must have been informed that, okay, I'm going to accept your offer. So acceptance will be in opposite to the offer. So one has made an offer and another person is going to accept. So that acceptance we are talking over here. Mental acceptance is no acceptance. So when mentally we think, okay, I will say yes. So it's in your mind only. So that is not an acceptance until and unless it is being explained, it is being expressed, it is being given orally or in writing. Or acceptance must not be derived from the silence. So silence is not considered as an acceptance. When you remain mum, when you remain quiet, so it doesn't mean that the acceptance have been given by a person. Acceptance must not be preceded to the offer. So it is when an offer is given, so one must say yes or no towards the same thing. So next term under this is consideration. According to section 2D of the Contract Act, consideration is defined as when to the desire of the promisor or promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or to abstain from doing something, such an act or absentia or promise is called as consideration for the promise. So that is into the promise part. So let's go into detail. When a party to an agreement promises to do something, he must be getting something in return. That something is defined as a consideration. So in simple words, we can say when I am having some agreement with some party, fine. Suppose I offer a chocolate to my friend. So here's a chocolate for you. Again, he says, I have also bought a chocolate for you, or I have also bought a cold drink for you. I have bought a candy for you. So candy is given me in return. So that is an agreement. Another example, if some person is giving some services to me, suppose there is a person who is painting at my house, who is going to paint my house. So he is going to paint my house. In return, I have to pay him his labor. So I am going to pay money to him. So paying that money to him against painting my house is known as the consideration. So money which I have given to that person is known as the consideration over there. So for one or the another act, when we are going to give something in return to that another person, so that is known as the consideration. Next are the legal rules as to the consideration. It must move at the desire of the promisor. So when the promisor says, yes, okay, this is going to happen, then only the consideration is going to happen. It may move by the promisee. So when the promisee, when the person who has given the promise, when it is going to act according to his willingness, it must be past, present, or future. So past, and past, he has painted my house and I have given him 5,000 rupees. He is painting my house. I'm going to give him 5,000 rupees. He is still painting and I have yet to pay him. So that would be future. I will make him to paint my house and I will be offering him 5,000 rupees. So that will be in future. That is going to happen in future. For now, he's painting and I have to pay him. So that again will be in the present or future. It need not to be adequate. So it's not necessary that it will be adequate only. It must be real. And real it would have happened. It must not be imaginary. It must not go into your mind. Okay, I will do this. That is just an imagination of my mind. No, it must happen in a real form. It must not be illegal, immoral, or opposed to the public policies. Suppose I make any child work at my place. So child labor is not allowed. It is illegal. So how it can happen? So I cannot make any child or any one who is minor to work at my place. So who is minor, who is below 18. So he cannot work. Fine, he cannot go for the labor part. So that is illegal. So that is not acceptable over here. Next are the strangers to the contract. Okay. It is general rule of the contract that only the parties to the contract can sue or be sued on that contract. The rule is known as the doctrine of privity. That is the relationship between the parties of the contract. So when two parties are over there, so contract happens when two parties are over there, party A and party B, they are over there and they are going to have a contract between them. if any one of the party, if any one of the person says no to the another thing, so that can sue him, or he or she doesn't obey by the condition, so another person can sue him. Sue him means he or she can take the another party to the court. So that can go for the legal obligations. He or she can take that person to the court. So that is known as the doctrine of privity. So exceptions are a trust or a charge, marriage settlement, partitions, or any family agreement, exproprial, assignment of the contract with the agent, or convenient running with the land. So these things would all come to the strange to the contract. So there are always an exceptions which are happening over there. So contract without consideration is void. Yes, when there is no consideration over there, so that is known as the void. When it is going to happen as a void? When there is love or affection. Compensation of voluntary services. So when some compensation is given in return of some voluntary services. Promise to pay a time, bar debit. So for some time we are going to pay something. So a complimentary gift is given to someone. So there is any agency to see the things, or charity is going to happen. Some kind of non-profit organizations are there. So we are going to do for it as a seva kind of thing. So contract of the bailment. So under the section 148 of the Contract Act, these all are without consideration, are known as the void contracts. Next, if there is no consideration, then it is not considered to be as a contract. So no consideration means no contract. There was the famous cases which were going in the court. That was the Abdul Aziz versus Mazoom Ali and Gauri Muhammad. So these were the when there was no consideration and no contract happened over there. So that's all for today. Hope it was the things were clear. Thank you, and for patience learning over there. Thank you so much.